Ladies and gentlemen, welcome back, and to our virtual audience listening in. My name is Lieutenant Colonel Lori Lincoln. I am the Chief of Plans, Policy, and Partnerships at the Office of the Staff Judge Advocate at U.S. Cyber Command. Our next panel is extremely timely, and it's often a hot-button topic, both within and outside the government: the purchasing of data. What are the concerns with this? Why does the government need this data? Does it circumvent the Fourth Amendment? What is its value? And is it data or data? These are just some of the questions that this panel will tackle. And if you think that we only stack the panel with government insiders, you are wrong. We have a diverse group here with differing viewpoints. That's what makes this conference so great. I am excited to introduce our moderator for the panel, Mr. Eric Rosenberg, who is the Acting Chief of Acquisition and Tech Transfer in the Office of the Staff Judge Advocate at U.S. Cyber Command. And in case you're wondering, he calls it data. Over to you, Eric.
Watch Star Trek often say data. It's a typical theme. So I've revealed myself as a Trekkie. Non-endorsement. So I'd like to introduce our really great panel. So we have Lindsay Rodman. She is from the Department of Defense Office of General Counsell. She's the Associate Deputy General Counsel for Intelligence, and she's basically been the lead on public available information, commercially available information, what we call PAI, CAI issue. She's really been at the front of that, working on DoD's policy to kind of give us more guidance on how to handle it. And then we also have Mr. Eric Eichhorn. He's from the CDAO, that's the Chief Digital and Artificial Intelligence Office, and he's Director of Governance. We also have Mr. Aaron Mackey. He is from the Electronic Frontier Foundation. We're really happy to have him here. I think this could be beginning a greater dialogue between our organizations, between Cybercom and EFF, but also DoD and EFF, and as well as with the interagency. So it's great to have you here. He's the Free Speech and Transparency Litigation Director. We also have, to my right, Brandon Pugh. He is the Director and Senior Fellow at R Street Institute, and he's in charge of cybersecurity and emerging threats. He also, in his reserve capacity, he works at the Army JAG School as well as a professor. So that's our distinguished panel. I'm really honored to have you guys here. So just to kind of set the stage for this discussion, the issues of publicly available information, commercially available information, it's really, really important. You think, data, that sounds kind of boring. Your eyes glaze over, gets really abstract very quickly, but it's really, really essential. This is really at the heart of what we do as cyber operations attorneys, as acquisition attorneys in cyber. This is really at the heart of everything. Things are in flux right now. There's discussions in Congress about potentially having changes to statutes. There's also DoD policy that's pending. Cybercom, we're drafting our own policy, and right now I'm working with different folks at Cybercom on that, to try to regulate that. We're already starting to incorporate clauses into our contracts at Cybercom to try to sort of address issues about data privacy and things like that. At Cybercom, we purchase data for a variety of purposes. So for intelligence purposes, for cybersecurity purposes, operations, as well as R&D. And that makes Cybercom a little bit unique because we buy it for a variety of reasons. And each, these different purposes, and it's really important here for capability development and to support the warfighter. And I think this is really an opportunity, one, to show more transparency on this topic to the larger public, as well as to get, I think starting a dialogue and an opportunity for us to get feedback. Because policy is in flux, we have a chance right now to shape that policy. I mean, you have Lindsay right here. This is an opportunity to give that feedback on what the larger national security community thinks should go into these policies, so we can balance national security with civil liberties. And just one more thing, there's sort of three big policy goals we have to kind of think about. You have national security, civil liberties, and sort of this internet economy that's based on advertising, technology, and data. and it's hard to achieve all three perfectly. You can maybe get two perfectly, because if we were to not buy this data at all, if we relied on no one to buy the data, then you wouldn't have the civil liberties concerns, and our adversaries wouldn't be able to buy it. However, the internet economy would suffer greatly if we couldn't buy the data, and so, if no one could buy the data, so in that world where we can't, prevent anyone from buying this data, we have to have compromise, and that's what we're going to discuss today. So, first question is going to go to you, Eric. So, could you talk to us about what is PAI, CAI, and where do these data sets come from, and why does the government need them?
So publicly available information, and that includes today's conference, so congratulations, is information that has been public or broadcast for public consumption. Formal reference, because I heard that I was going to a legal conference, is 3115.18. Commercially available information is a subset of that. So it's information that's been made available to the public and is available for purchase, specifically either by governments or the public writ large. Some of the different types of commercially available information that we purchase, because we are a huge department, we have data activities that run the gamut. So we do research and development data, we do weather data, we also do Internet of Things data, we look at financial data, we buy legal data. Some of the different uses, in addition to normal intelligence activities, we also use it for things like background investigations, insider threat, network analysis, which I'm sure is near and dear to cybercom. We also use it to look at supply chain vulnerabilities. That's a huge area of growth for us.
Great, thank you so much. Lindsay, would you like to kind of help lay out what the current legal and policy framework is for purchasing data? And if you have anything you want to add about how we use data.
Sure, thank you, and thank you so much for having me. I really appreciate the opportunity. So the terms, especially in conferences like this where you're bridging the gap between folks within DoD who are using a certain vernacular and then folks on the outside who are using different vernacular, Eric very helpfully laid out what we mean when we say PAI or CAI, publicly available information or commercially available information. Those terms originate from Executive Order, PAI originates in its DoD usage from Executive Order 12333. So those of you who have worked within or among or with the intelligence community, that's our Bible. I carry it with me everywhere. I have a copy here if anyone wants to reference it. And EO 12333 originally signed in 1980 as an effort to kind of clean up what was perceived as intelligence community misbehavior, shore up the rules, get us on track with a strong eye towards protecting U.S. persons' information in the hands of the intelligence community. And one of the, frankly, exceptions to the rules as they applied to the intelligence community about the information that they were bringing in. A lot of the rules were softened for publicly available information or information for which the person concerned has consented to its disclosure. So right off the bat, we were using the term publicly available information in a sort of, Venn diagram of there's private information over here in a circle, and then the two circles don't touch. There's also public information over here. And what's in the public information is stuff that is akin to what someone would have consented to being out there and usable, right? That's how we were thinking about it before technology started muddying the waters. Now we live in a world where there is public information, at least the way that I like to think about it. There's private information, but those two circles overlap. And there is, in the middle of that Venn diagram, a world where there's information that is what we would call public information, because it's accessible to the public openly. It's data that one can purchase relatively freely. There's nothing illegal about obtaining it in these ways. But that has serious privacy concerns associated with it. There's kind of an obvious bucket that involves things like doxing and revenge porn, right? Like things where someone has done something illegal or nefarious in order to release what you would consider to be private information out into the wild. But there's also data about you that's floating out there that you have ostensibly consented to through terms and conditions and stuff like that, or that's just collected from you as you're out in the world. but that you might have an ick factor associated with being fair game for DoD, the intelligence community, private companies, anyone, frankly, accessing and learning about you. You know, for those of us who, well, I drove here today, but when I'm on the metro, I'm there doom scrolling and candy crushing just like everybody else. And I have probably ignored lots of terms and conditions that allow people to know exactly where I'm going. Luckily, I work in, you know, with the intelligence community and in the Department of Defense, but not in a role where, you know, I guess I know that I'm vulnerable to people sort of tracking me and understanding where I am, and I guess my OPSEC isn't particularly good, but I'm going to guess that a lot of you guys are in the same boat as me. So some of that data, as Eric suggested, comes from, you know, sort of literally being able to track where you are at any given time, what your preferences are, what you're saying out in the world, what are you putting out on social media. All of those things are ways that someone else might be able to gain an insight to you. And I'm doing a lot so Eric was like, what is the policy? And I'm giving you a whole lecture on public and private and Venn diagrams and whatnot, and I haven't even gotten there. But the reason I'm doing that is because the point I'm trying to make is that we got here through lawful conduct, right? So we're in a place where people were sort of using the law sometimes, but also just working within the law to enable conduct that fuels the internet economy, as Eric mentioned. This is stuff that, you know, if you were to regulate highly, would actually really fundamentally affect the internet marketplace. Now, that might be something that we as a democracy decide we want to do, but we haven't done it yet. So, okay, so what is the law when it comes to all of this stuff? I had the opportunity last week, to speak to non-lawyers about Fourth Amendment obligations, and that was much more comfortable because I didn't feel like everyone's going to be judging my legal analysis. This is a little bit more, I think maybe friendly but scary audience. So where does Fourth Amendment analysis start? Usually we start with Supreme Court for the lawyers in the room who've, you know, did con law and then immediately started practicing in the Department of Defense and then didn't do con law again. So Carpenter v. United States, many of you will have heard of this, some of you will not. 2018 Supreme Court case. This is, if you went to law school back 20 years ago, like I did, if you were on the older side of the audience, you will remember we did Kelo. There were certain other Fourth Amendment cases that talked about technology and what could be seen and known about people. Well, since we all went to law school, 2018, Carpenter came out. Carpenter is a case where 4 men were convicted using cell site location data that was compelled by a magistrate judge. So what's important to kind of understand about that fact pattern when we try to think about its Fourth Amendment implications was this was not data that was obtained freely on the commercial open marketplace. This was data that was compelled by the company, but it was not compelled using a warrant. And the Supreme Court struck that down and said, no, if you're going to obtain this type of personal information, and this was pattern of life geolocation establishing data, that is a bridge too far. You're going to need a warrant. You're going to need the legal protections associated with obtaining a warrant if you're going to go as far as to compel geolocation information about individuals to establish pattern of life. In that case, Chief Justice Roberts also said, our decision today is a narrow one. Our opinion does not consider other collection techniques involving foreign affairs or national security. So, you know, the young lawyer, enterprising lawyer for the Department of Defense can read that and say, oh, thank God, we've got an out clause. We don't need to leverage it. There's nothing in the opinion about commercially available or publicly available information, and it's not supposed to apply to the national security application anyway. So we've got our get out of jail free, thank goodness, because if we had to get a warrant in every case, that would be a disaster. But I don't think that's actually that is not actually how the conversation has gone down in the legal community in the Department of Defense. We've all taken Carpenter to heart, and Carpenter has shown us, and I mean, in the conversations that I have with Eric and with many of my other colleagues around the Department of Defense and in the intelligence community, Carpenter signals to us that the Supreme Court and the public and Congress and, you know, in these broader conversations takes very seriously the question of the sensitivity of geolocation data and what it means to establish pattern of life on people, and that we should be thinking very seriously about protecting it and safeguarding it, understanding that it does raise an ick factor for people, and it does raise privacy and civil liberties associated concerns. So whereas I think the jury's still out about whether there's really a Fourth Amendment right associated with all of this, I don't know, you know, I am not the administration spokesperson on what carpenter means for the department or anything else. I do think it's fair to say that it really informs our Fourth Amendment analysis, and it more broadly, because we go past what the Fourth Amendment compels, it really informs how we think about where we need to be going in terms of safeguards, guidelines, and guidance to the field about what our obligations are associated with data that presents these kinds of sensitivities. Okay, so I see within the intelligence community in 2022 a senior advisory group led by, you know, some of the most distinguished lawyers in our community wrote for ODNI a review of the IC's use of commercially available information. And that was very, very close hold, and I was at a conference last summer about the conclusions of the senior advisory report, and, you know, I said, I'm sorry, I can't talk about it, you know, it may or may not exist. And I go out, and in the hotel lobby on CNN, I see ICCAI report is released, and, you know, so no one told me, but apparently it's public. You can Google it on CNN. They've got it. It's there as of last summer, and it will tell you. I think it's a good and thorough rendition of what the privacy and civil liberties associated implications are of the IC's use of CAI, as much as we could publicly release. But frankly, there's really not very much redacted in that report. And they reached 3 conclusions. One was that we really needed to do a better job of data cataloging because we weren't doing a great job of responding to the questions about, you know, like, what do you have? And we're like, oh, stuff, you know, and there's a lot of hand waving. And some of that was because we couldn't say it in an unclassified setting. And some of it was because we hadn't actually done the work to go back and understand how people were using this information. Some of that is because it's really used at a grassroots level, right? So it wasn't like a top-down acquisition of this data. Oftentimes people were acquiring it at a lower level. And so you had to understand we had to establish the right capabilities to have that reported up. And number 2 and number 3 were to identify which commercially available information presents sensitivity concerns and establish standards and procedures to govern it a little bit better than we were doing already. Now, it wasn't that we were operating in a vacuum. Those of you who work in the intelligence community know the DoD manual 5240.01 provides a lot of guidance on what to do about protecting U.S. person information, and that applies to commercially available and publicly available information as well. So, you know, there were retention limitations and, you know, guidance on when you can use this information and safeguards that you need to take associated with it. But these enhanced sensitivities associated with sort of new privacy concerns around this data merited a new look. So ODNI is now nearly complete with an ICCAI framework. Some of you know this because you've been in the working group meetings and the implementation and all that. And that is set to be released any day now. I asked my IC colleagues at ODNI what kind of cleared talking point, like what can I say about what's in this? And they wrote the following talking point for me. My colleagues at ODNI are the best, and I really love working with them. Thanks, guys. And then they thought I wouldn't actually say that at the conference. I was like, oh, no. If that's what you give me, that's what I'm going to tell them. You know, what I can tell you is that it establishes 9 principles, and it provides a means of determining when CAI, because as Eric said, CAI can be weather data, right? But when CAI presents the kinds of privacy and sensitivity concerns that we're talking about, then there's basically a whole rubric of requirements for doing that analysis and then putting appropriate safeguards in place. So that is coming literally any day now. We thought perhaps it would be released this week. I think that may not happen at this point. So DoD is also putting together its own CAI framework. And Eric and I have been in some painful and some not so painful meetings in the drafting of this policy. It is now in coordination in CADMS. So if you have opinions about this, find your local person with CADMS access and go to town on the critical comments. I say this because we really, truly want this policy to be workable for the whole department. So now is the opportunity to get that feedback into the policymaking process. And that will both cover DoD's IC elements, but it will be for the rest of the Department of Defense. And it's meant to kind of carry forward the important work that the IC has been doing in this regard to the rest of DoD in a way that makes sense as applied to DoD. Now, DoD also is not without its existing privacy framework. There's the DoD Privacy Program. Eric cited 3115.18. That is our current policy directive that governs publicly available information that is already in place. And we also have DoD Directive 5200.27, which is titled Acquisition of Information Concerning Persons and Organizations Not Affiliated with the Department of Defense. So we have policy that currently governs how we work with this stuff. It's just that the way that technology has recently developed, we've recognized that we need to do a lot more, both because it's the right thing to do, but also to signal to the public and to Congress and to folks who are looking all the way from California at what we're doing, that we're trying to do the right thing in this regard. These policies go beyond what is required by the Fourth Amendment, as far as we know what's required by the Fourth Amendment. They go beyond what's established in law right now. But they don't have the force of law. They will be policy, they will be regulation. So if there is any future legislation, then that's something that would fall on top of them. I know I've been speaking for a very long time. Eric said I could talk as long as I want. That's his fault. But I will say one more thing. The vast majority of the missions that the Department of Defense is performing in the intelligence community and outside have absolutely nothing to do with U.S. person information. It's just not relevant to what we're trying to do. And what we're trying to do, people are mission focused. There isn't an interest or desire to get into U.S. person information because it doesn't serve the mission. People want to do their job, do it well, and then go home and hang out with their families or crush candies on the metro, whatever it is that they're doing, right? So there isn't a sort of like deep hunger to obtain this information beyond what is mission enabling. However, there are certain missions that do require digging into this information, and for those, that's what we need the extra safeguards in place. But I think also for those of you in the audience who work within the department on these issues, not only is it not particularly helpful for the mission, I interact with folks in the IC especially, but also DoD every day who are like, I don't want U.S. person information because it makes my life so much more complicated to have to navigate the restrictions and the safeguards and the sort of the bureaucracy that we have put on top of it. There's no one sitting in the department who's like, ooh, I really want U.S. person information. That would be so awesome. It sort of doesn't, it doesn't really help. That's not a fair characterization of what we see as people are interacting in the Department of Defense, nor is anyone sort of accusing DoD of doing that necessarily. But I think it's important to highlight that that the type of guidance and safeguards that we're putting in place are really meant to make someone think twice about whether they need that information and whether they're going to do the appropriate things to safeguard it when they access it. And making them think twice is actually, hopefully, a step in the right direction towards doing what we need to be doing. So, thanks.
Lindsay, thank you so much for that. Really appreciate that rundown. Also like to add that we may touch upon this more later, that Federal Trade Commission has also entered these discussions. There's been some recent orders that have been issued with respect to data brokers, and so that's also now kind of at play as well. So Aaron, could you kind of give us a bit of your perspective on the government procurement of PAI, CAI, and also what reasonable safeguards would you hope would be put into place that aren't currently in place?
Right. So thank you for having me. Particularly thank you, Eric, for organizing this panel and making sure I got here. So I think big picture, where EFF comes from is we come from a place of wanting to ensure that people's rights, particularly their constitutional rights, are protected. And so our view is that the Fourth Amendment should be the guiding star of all of these protections. And it's great to hear that DOD is taking to heart Carpenter, which we read as really sort of a sea change, and recognizing a lot of sort of undercurrents that I think are real, including sort of the fundamental idea that that the information we provide, whether that's location data or other sort of personal information in the context of surfing the web or using an app, that we consent to that data. And then, as Eric just described, I think the FTC is also acting in a way that that raises questions about whether that collection is itself lawful, in ways that I think implicate the policies and sort of fundamental principles about the collection of this information in the first place, if it is legally collected. I think there are concerns about whether that's actually true now. But I think more particularly what we think about is how do you protect people's privacy and honor their First Amendment rights and their Fourth Amendment rights throughout the life cycle of the data itself. And so that starts with collection. It also begins with use, retention, and disclosure. And I think, sort of looking high level, and I'm not deep in the regulations like you all are, but I think a lot of this, once there's sort of collection, it's sort of seen as use limits are pretty limited, and there are retention limits, which I really appreciate. But some of the disclosure limits that are sort of like, do you have a reason to know or a reason to use? I think those are sort of concerning. And what it looks like from an outsider is that once we obtain this information, as long as we obtained it lawfully and we purchased it as anyone else could, we can essentially do with it what we want and disseminate it further. And I think that looks quite different from the sort of normal Fourth Amendment analysis that a court would apply, which would ask at every step of the way, does a user or does that individual have a reasonable expectation of privacy? And to the extent that the government action implicates it, is certain legal process required for that initial search, the collection, the retention, and dissemination. And so I think it's great to hear that there's forthcoming policies that are really trying to align with the Fourth Amendment. But I think there's probably more work to do in trying to actually ensure that people's Fourth Amendment rights are protected. And I do think that DoD needs to take a hard look at whether or not this collection is lawful in the first place. And I know we'll talk about some of the FTC settlements, but basically what happened, right, is a number of location data aggregators have been subject to civil enforcement under the FTC's Section 5 authority on the theory that their collection of this information itself was unlawful because they deceived consumers, right? And that's not just sort of the general deception that we all sort of walk past when we scroll through the endless terms of service, right? Where they say we get to do with your data what we want, and we also have a get out of jail free card, right? But the FTC actually held these companies to account, and then one of the remedies that they issued in at least one case was a prevention of this further sale of that data. And so I think what's important to understand is if you start at the outset from this belief that the purchasing of CAI and PII is itself fully consistent with the law, I think the FTC and potentially Congress is acting in a way that might say that that's actually not true. And so I think that might shift a lot of the thinking, and hopefully we'll see policies that reflect that reality.
Thank you so much for that. Really appreciate it. Brandon, so I guess, what's your sort of take on this? Do we have the right protections in place right now? What should we add? Thanks.
Yeah, no, Aaron kind of teased it up well. He mentioned Congress's action, but before I get there, I want to kind of take a step back and reflect on something the commander had said this morning, which was great. I was texting Eric during his remarks. I'm like, this is great. He mentioned privacy in response to a question, but a different dynamic of privacy. Obviously, the risk and the threat of adversaries collecting and potentially using commercially available information against our service members. And I think it's helpful to take have that lens as well as a force protection issue. And if that at all interests you, the Army Cyber Institute, I know there's a few of you here, and I have done incredible research around that, specifically looking at how China and other countries are collecting as much information as possible and leveraging it against us. And we see it playing out in conflict present day, and that's even an open source. But taking a step back to Congress and what they're doing, outside of specific sectors, whether it be finance, healthcare, or even what the DoD is doing, and then specific states, there's largely no framework on data and privacy and the security of that data in the United States, which is astonishing because countries around the world have similar laws, but there's no comprehensive federal data privacy and security law in the United States. So largely speaking, you're free to collect as much information as you want. share and sell it as you wish. Obviously, there's some limitations because you say you're doing something and you're not actually doing that. FTC is going to come after you. But it's more ad hoc. There's no comprehensive approach. Aaron kind of teed it up, but Congress has been looking at this for, some of you in the room we've been working on this longer than me, but well over a decade. And there's been a lot of disagreement on what a federal law could look like. And balancing the needs of consumers, industry, to Eric's opening, it's key to our economy and emerging tech. But then also like the security and national security space. How do we balance all three of them? And that's been a constant struggle. And many people had said I was an eternal optimist and that likely we never would have action on a comprehensive bill. I mean, not to make this bill specific, but it is interesting that this past Sunday, we saw a compromise emerge between the Democrat chair in the Senate and the Republican chair in the House. I don't want to oversell that. It still has a long path forward, but it does a lot around data collection, and it targets data brokers. So it has the potential to be pretty extraordinary if it passes. Not saying it's perfect in every regard, but it does a lot. But just briefly, what does it do for data brokers? It's designed to bring a lot of transparency to data brokers. So no more would there be the data broker that nobody's ever heard of or has a very tenuous relationship to a legitimate company. They would have to register through an FTC registry. They would have to have a public website where they're notifying you and everybody here that they are in fact a data broker and this is how they're leveraging data. And it would also have a do not collect registry. And that's maybe a little sensitive for those in this room because the law enforcement community has had some concerns around that. Because would criminals or others avail themselves of that? So that's pretty interesting. But at a broader context, it does a lot more on how data is collected in the first place. It relies on data minimization. So essentially, there would be 15 permissible purposes for collecting and utilizing data. And security is a component of that. Law enforcement is a component of that. But outside of that, no more would there be the days where you can collect as much data as you want, regardless if it's actually necessary for a product or service. So happy to dive more into that, but there's a lot there.
No, thank you so much. So I'd say, Lindsay, do you want to touch upon any kind of current legislation to the extent you can talk about that?
Yes. Eric's trying to see how much he can get me into trouble today. So first, I'd love the opportunity to respond quickly on the FTC stuff because obviously that was something that the legal community within the Department of Defense and the ICU was like, oh, okay, here we go. And so for those who aren't tracking the FTC, I mean, Aaron explained it perfectly. Like they are starting to really look into questions of data broker behavior, what is fair game from a consumer protection standpoint, and the thing I think that's most interesting to us as we nug through what should the DoD policy look like is how do we define which data presents the most sensitivity concerns and what reasonable safeguards what do reasonable safeguards look like? What should we be putting in place for this kinds of data? So the decision we're talking about is X-Mode Social, by the way, in case folks want to look it up later. And ultimately, there was a complaint that had, frankly, mentioned sale of information to national security agencies in it, so we were watching it. The ultimate settlement and order did not have really anything to do with those potential use cases, and frankly, I mean, that was really not what the case ended up being about. But X-Mode Social was selling data, as Aaron mentioned, in contravention of its own terms and conditions, right? Even not what it said that it was going to be able to do. But what was most interesting, at least to me, was that in the settlement and order, they actually defined for the first time which information, which data about individuals presented the biggest sensitivity concerns. And so I think one can fairly look forward and say, okay, these categories of data are going to be protected beyond just whether X-Mode Social can continue to sell this data, which the answer is they can't. And that was geolocation information that associated people with locations that presented privacy concerns. The big two that stick out in my mind, I think there were 6, are certain healthcare clinics in Ohio, right? And then other would be geolocation information that would give away LGBTQ affiliation or status, right? So you can imagine, you can think about that data and think like, wow, okay, yes, I I would like there to be restrictions on people selling geolocation information about which healthcare clinics I've been to. That seems reasonable. So so we are also sort of interested, and we see FTCs paying attention. And it is important for us to know, and we always want to know, if the people that we're dealing with have obtained the data in an above board manner. That informs a whole lot of things that we care about. And in most cases would mean that, you know, there's no way we're going to even continue to look into that information. So, so that's FTC. On Congress, yeah, so I think you're talking about Senator Cantwell's proposed legislation. So that is really interesting because it is sort of a interesting, serious attempt by Congress to govern the space more broadly. We also have seen a flurry of legislative action that is focused on IC and law enforcement agency uses of commercially available information in particular over the past couple of years. So there have been a lot of incarnations. And what is interesting here, and Brandon kind of touched on it, is that this is not a partisan issue. Like, the people who come together for these bills come from different political backgrounds, and that, you know, for civil servant, like, then I can talk about it with, like, there isn't really a partisanship associated with this. We're just talking about the issues and the policy, so that's actually kind of an interesting and refreshing place to be. I wish they weren't trying to take DoD CAI away, but it is interesting to be in that world. Okay, so last year we saw a House amendment to the National Defense Authorization Act that would have prevented the Secretary of Defense from obtaining commercially available information, essentially that had to do with U.S. persons. We saw that as very concerning, right? I think we've tried to explain that this information is important and can be quite valuable. It also presents privacy concerns. So, you know, we want to live in a world where we're doing the right thing, but also able to use this information to keep Americans safe. There's also a Government Surveillance Reform Act that was introduced in the Senate last year. Right now, there are kind of two major live actions having to do with this, having to do with CAI. One is that the House on Thursday is going to vote on FISA 702 reauthorization. That has nothing to do with CAI. FISA 702 is about wiretapping, signals intelligence. CAI is about purchasing data that is freely, openly, commercially available in the marketplace. However, they both are things that the intelligence community uses to learn stuff, and so those two issues have gotten, I think, quite conflated in Congress. So you saw during FISA 702 reauthorization a number of efforts to tack on amendments having to do with preventing the Department of Defense or the intelligence community or law enforcement, or all three, from obtaining commercially available information. And then you get all sorts of, like, rules, issues about whether it's germane, and, you know, things that are totally beyond what I pay attention to normally. You know, I go to these meetings, I'm like, just tell me if the amendment's in or not in, whatever. And so those two issues have now been split in the House. But what that is doing, it is people are now paying attention to the fact that there is a vote on FISA 702 on Thursday. But there is also a vote on what is called the Fourth Amendment's Not for Sale Act, also on Thursday on the House floor. The Fourth Amendment's Not for Sale Act is a very catchy name. If, like, whoever came up with that, good marketing skills or something. But the Fourth Amendment's Not for Sale Act would make it illegal for the IC or law enforcement agencies to obtain commercially available information about Americans or about anything that's happening in the United States, full stop. It would, for those of you who are in the Department of Defense, place serious obstacles in the way of us performing our mission on a daily basis. So I personally have some concerns that about that legislation, that because FISA 702 has more attention and has been sort of an issue for longer, that folks are sort of forgetting that this other vote is happening on Thursday. There's also a bill in the Senate that's called the SAFE Act. It stands for something. I didn't write it in my notes. I apologize. You can Google it later. Aaron might know. And that would require a warrant for CAI access. But again, it presumes that we would go to a court under circumstances where a warrant would be feasible. So there's a lot of concerns that we have about that bill as well. It's been marketed as a compromise bill, but it has exceptions that we can't use, and it still requires a warrant. So it's still ostensibly, at this point, when we look at that bill, we say, okay, that just prohibits our access to CAI for IC and law enforcement purposes, which, again, would stop a lot of things in their tracks. And, you know, as I mentioned earlier, and I think as we're all kind of in agreement that we all share an interest in, well, I'll speak for everyone on the panel now. we all share an interest in putting reasonable, you know, sort of safeguards in place on Americans' privacy, and then, you know, what you deem to be reasonable, I'm sure, will vary as people vary. But from where I sit, we also have a concern about helping facilitate the Department of Defense to perform its mission and not to hamstring that to the point that we're actually making people unsafe by putting these restrictions in place.
So much for that. Aaron, do you have any thoughts on, I guess, on the current legislation?
Yeah. So before I get to that, I think what's interesting is also to draw the parallel between so the X mode, the FTC's order on sort of what information is particularly sensitive, right? Where does that come from? It actually comes from Carpenter. So Carpenter describes not just concerns about pattern of life analysis, but the fact that you can use location data to put someone at a particular place or location, and whether that's a healthcare facility, a bar, or some other place that's sensitive, right? And so I think what's important is there is a through line in this that's recognizing the fundamental concerns here. On the sort of, you know, legislation, again, like, I don't know your world at all. But where we come from, again, is from a place of the Fourth Amendment. And so when we see a decision like Carpenter that really sort of recognizes the Fourth Amendment rights of individuals to be free from this sort of search absent sort of government getting a warrant, we then see a few months later, right, the same data is available and is purchased. And we have concerns that essentially what that looks like to us is a way around the Fourth Amendment. And I'm not accusing anyone of violating the Fourth Amendment, but that's what it looks like from our perspective. And so we see bills that require things like a warrant when the same information, if you sought to compel it via FISA or others, would have required, other authorities would require a warrant. We say, why should that not be the case here? And so I think we are generally very supportive of proposals that will respect Americans' Fourth Amendment rights. And so we generally support these proposals because we feel like they do establish a baseline that is actually responsive to what the Constitution requires.
Thank you, Aaron. Brandon, do you have any thoughts on?
Yeah, maybe just a couple additions. I think they both have made great points. I guess to play devil's advocate on the FTC side, I think the FTC has a key role in privacy, and they have a history of doing it. The downside is, you know, a lot of it depends on who is leading the FTC at the time, not just political composition. You know, their priorities change, definitions change over time. So I think that is the risk of not having something codified, whereas Congress is making the definition and Congress is setting forth a policy direction, because what we deem sensitive today may not actually be sensitive in 3 years from now. So that is one concern, and just personal opinion. Like, I think the FTC sometimes is overstepped. Not saying necessarily on that particular case, but in the past, we've seen them go a lot farther, and people question whether they actually have the legal authority to go on that path. Not to make this an FTC panel, but, you know, it's sometimes hard not to. You know, another neat you know, we've talked about the NDA a lot, but another really neat provision that I don't know if anybody's talking about it, but maybe your world in acquisition is Section 803, essentially, you know, putting an obligation that if DoD is contracting with another entity, there has to be a provision in that contract that they cannot sell it to a third party. You know, Eric's more the expert than me, but it's really neat because it's, you know, giving the DoD an obligation now to protect service member data, and not just service member, but also DoD civilian data. Because oftentimes, I shouldn't say oftentimes, but that has the potential to be resold or transferred or potentially acquired by adversaries. So I think the DoD now is doing something to, you know, prevent some of these risks in the future.
No, thank you for that, Brandon. And Eric, I think, would you be able to kind of touch upon, so a lot of these Fourth Amendment for Not for Sale Act incarnations, they talk about carve-outs for, if you can make sure it's not reasonably de-anonymizable, the data, could you kind of just touch on the practicality of that?
Yeah, I'm not sure that is it's not necessarily practical. So yes, you can do things like you can strip out identifying information from the data set. The idea that nobody else is ever going to be able to merge that back in with another data set is not a practical requirement to put on us in particular. Now, what I have seen with processing of data sets, so specifically geolocation data sets, is a lot of entities will have filter rules. So step one, filter out anything that looks like it's U.S. If it's lat long, that's easy. Okay, and that goes, and you filtered that out, and that's now in a separate category where, yes, you have to have a clear need to access that. Nobody can just go in and get that information if it's U.S. After that, it's okay, now you might have something that still allows you to identify an individual. So maybe you have a device ID, an advertiser ID, something else that can be traced back to an individual. There are ways to obfuscate that data. You can use hashes, you can encrypt it, or you can drop the column when you move it. Our preference is that if you don't have a need for that specific column, drop it before you move it for any other use. And if you do have a need for that specific column, obfuscate it if you can. If you can't obfuscate it and you can't drop it, then you have to have a clear need to know to access that information with that personally identifiable, and a lot of it's personally identifiable type information, again, or something of concern like an advertiser ID or a device ID.
That. Lieutenant Colonel Lincoln, how much time do we have left? 15 minutes? Okay. So next question I wanted to talk about was, there's an executive order that was recently issued about sales by data brokers to certain foreign governments. Lindsay, do you want to touch upon that?
Sure. I'm going to do the same thing I do every time you let me talk, which is talk about what I want to talk about and then answer your question. So just to touch on what Aaron mentioned earlier, I think that most folks that I talk to internally in DoD, when we're just sort of like water cooler chatting about this stuff, which we do because we're nerds and we think it's really interesting, is that reasonable legislation that will place boundaries on what data brokers are allowed to do, on what terms and conditions need to look like, on what decisions people can make about putting their own data out into the world and how it gets leveraged. That is something we need as a country. Our concern is that it's available on the open marketplace for anyone to purchase, including our adversaries, including anyone who seeks to do us harm, but that we would be hamstrung in obtaining it and using it to protect ourselves, protect not only our service members, but protect the United States against what our adversaries can learn about us. So that is the primary concern. If there were a law tomorrow that said, data brokers, you're no longer allowed to sell this stuff, then we would have to leverage whatever legal processes there are for DoD to obtain information that is otherwise not available in the marketplace. And there aren't that many ways that we can do that, right? So we do have authorities, for example, if we could find it through signals intelligence, then we would have to abide by the very strict rules around using signals intelligence to get that information. But if it's not out there, if it's not for sale in the open marketplace, our need to see it, our use cases go down as well. It's by definition not publicly available information anymore. So you take it out of the category that we're concerned about. So I just kind of wanted to touch on that because that is, I think sometimes there's a sense that DoD, I don't want to, I think sometimes there's a sense that that we would, that this legislation kind of doesn't come from the right place from a DoD perspective. And I think we all want to see reasonable constraints. What we don't want is constraints on our access to this information before there are constraints on everyone's access to this information, because that goes in an order that creates a lot of concern for us from a risk perspective. Okay, data security EO. I got there. Thank you for humoring me. So in early March or late February, I apologize, I don't remember the date, the administration released the Data Security Executive Order. This is an executive order that places prohibitions and also limitations on certain transactions selling bulk sensitive data about Americans to countries of concern. So that is what it does broadly. Now, if you read the executive order, it is very long, and then you'll walk away saying, what are the rules? And there aren't almost no rules in the executive order because it basically establishes a rulemaking process. So right now, we're going into the regulatory rulemaking process. There was an advance notice of proposed rulemaking that went out that asked 93 pages, I think, worth of questions. Yeah, I got to legally review all of them. And it is out for public comment. Those public comments are due, I think, April 18th or sometime mid to late April, so it's still open. And what those rules will do is define what is the sensitive data, like what raises a sensitivity concern. So how are we thinking about defining the personally identifiable information? It doesn't use those terms, but that's in there. Very important from where we sit, protecting government, it's sensitive government data is the term that's in the EO, but essentially protecting information about all of you, right? The folks who work in the national security community from going over to countries of concern. So there will be different definitions of what do we think about sort of every normal American's privacy information versus government information, which would be information about government employees. And then what are the bulk thresholds associated with that, right? So at what point are we limiting these sales? The bulk thresholds for government might be 1, it might be 10. The bulk information that includes things like ad tech information, if it's sufficiently sort of certain columns are eliminated, maybe you can sell a couple thousand of those to China for reasons that you would have to justify. But that's essentially what's going on in terms of the regulatory process with the Data Security Executive Order. It is a really important first step. It places obstacles in the way of our adversaries, including PRC, and which ones are the countries of concerns is an Attorney General decision, but it includes who you think it would. But it is not by any means the answer to the question that we have been posing today. It does not solve our problem. It places serious obstacles in the way of our adversaries obtaining this information, but it will not stop the flow in its entirety. So we need to be doing other things to think about how to stop that flow and protect ourselves.
No, thank you, Lindsay. Brandon, I know you've written about this topic, so I know you want to contribute.
This is a passion of mine, something I've been working on for a few months now. I think Lindsay does a great job of giving an overview. Just to add a few points to that. The EO itself is great to read. Yes, it doesn't have a lot of substance, but it does a really good job of bringing together. Yeah, not that every EO isn't great to read, but this is a really exactly. No, maybe it just shows it interests me in life, but it does a really good job of compiling a lot of discrete statements by key leaders into one document. So, past cybercom commanders have spoken about the threat of adversaries and data, the FBI director numerous times, the administration, the National Security Council. They've put it all into one document and really outline it and give some new details that had not been publicly shared before. So really interesting to see. On top of that, it is not it's gotten criticism in a few regards, and just briefly talk about that, is resale. So if we prevent it from being sold to a data broker, what's to say that they won't then sell it to a third party, won't resell it to China or somebody associated with China? And there's provisions in there to get at that, but that's a challenge. Second is, to Lindsay's point, this isn't the be-all, end-all. We know adversaries are going to still continue to get data in other ways. Buy companies with it. Hack. Use publicly available information, or and so on. So it is part of the solution, not the entire solution. And I would say, it also calls out that not all data brokers are the same. Yes, there are very nefarious data brokers that will, for profit, willingly sell to these countries of concerns, and it identifies 6 in the. But there's also some others that are more legitimate that put themselves out there as data brokers and sell for fraud detection, tracking down victims of sexual exploitation, and so on. Last point on this. It's not the only solution. Like everything else today, we've heard about many House and Senate efforts. On this topic, there's also those. The House unanimously passed an effort to do something very similar, but a different mechanism. It relies on the FTC using their Section 5 authority. The Senate, under Senator Wyden, has a import-export regime, looking at essentially high and low-risk countries, looking at the types of data. So all that to say, we'll see what goes into place first. But there is a long path forward for this EO. It's not an immediate obligation, but the design overall is to prevent this from being an ad hoc and a case-by-case decision, and rather use these bulk thresholds as a guiding principle. But there'd be exceptions and also licenses available if there are some niche applications that were not being considered. So,
Brandon, thank you so much for that. So I'd like to open. How much time do we get? 5 minutes. So yeah, we'd like to open this up for questions.
Thanks. Couple of points of clarification. Lindsay, I understand and I get we need to be sensitive to the sensitivities of this kind of information and data in how we handle and use it and manage it. But that's different than saying the sensitivities of the data translate into reasonable expectation of privacy requiring a warrant to obtain it under the Fourth Amendment, right? I just trying to understand, it sounds like there's a line there that makes sense to me, if that line is there. And to Aaron, I confess I haven't looked at this in the Fourth Amendment context, but like your point about the FTC actions, United States versus White, the false friend doctrine, I mean, obtaining confessions or admissions through that type of arrangement where a co-conspirator is turned confidential informant has long been deemed admissible, like not violative of constitutional rights. So why does the FTC action transfer into a Fourth Amendment violation by obtaining that data that's still been turned over to a third party?
Thank you. I really appreciate the opportunity, because if I have not been clear, which obviously I haven't, it gives me an opportunity to kind of clarify. When I originally was talking about Venn diagrams and circles without a diagram and asking you guys to follow me, what I was trying to get at was this idea that this information presents sensitivity concerns that feel private, but they fall in the definition of what is public, right? You have consented via terms and conditions. It's freely available on the open market. And, I think there are special concerns that we need to have about information that, like the really nefarious use cases like the doxing and the revenge porn and stuff like that. I think there's, where someone has broken the law to put something into the public, I think there's a different legal analysis there. But if we're just talking about stuff that falls under the definition of public, then, from my perspective, that is not information where for the government to obtain it, to require a warrant or something like that, would be a constraint that is not required or merited under the Fourth Amendment. Where that information, so I will stop there. But that is where it presents sensitivities is where we can say, hey, the Fourth Amendment doesn't require a warrant in this instance. But it would not be good governance for us to therefore decide that we don't need safeguards or protections or reasonable guidance for its use. And that is where the government is right now. So thanks.
Right, and I'd like to add on to that. If the data contains sensitive attributes, we don't have to go all the way to requiring a warrant. There is a happy medium of, yes, we can put it in a secure environment. Yes, we can restrict access to it. Yes, you have to have need to know to get at that information, which is a far more reasonable requirement than going all the way to you have to have a warrant to get this.
Really quick response. I think on the question of the FTC, to the extent I wasn't clear, what I was trying to say was not that that creates a Fourth Amendment problem, but I think when I read the DoD policies, and particularly the OD&I report, it talks about a baseline of collection of purchasing this data on the theory that it's legal and it's publicly available. And I think what the FTC's decision does is actually calls into question whether the initial collection by the data broker itself was legal, and then whether or not then the DoD can sort of, consistent with its policies, continue to collect it in that way, because the FTC is saying the collection by the app that used the SDK that then sent the information to the data broker was illegal under Section 5. And then onto the Fourth Amendment analysis, I understand those cases, and I would just disagree that I think the scenario that we're talking about looks much different than a person wearing a wire or who's an informant. If that person is even one person, they have multiple interests that the user whose information is collected is completely powerless to actually understand and comprehend. In terms of the amount of information that's collected, who is able to collect it, and where it goes. It's very different, I think, than a physical world analogy. And so I think we don't have the case, right? So that is a law that, and sort of the case law and precedent that you could rely on. But I think as much as we look at Carpenter, and Carpenter says it's not like we consented to this and we voluntarily disclosed our bank records or the call details that we've sent over the telephone network, this is completely different, and I think that sort of theory applies here, and why it makes it sort of a different scenario.
Thank you guys so much for your time. Panelists, really appreciate your contributions. If you want to get them after, when we're on the break, they're here for you. Lori, over to you.
Thank you to our panelists. We promised you a very diverse group here, and I think we delivered here. So thank you on talking about how to balance national security while also safeguarding privacy and civil liberties. So for our virtual audience, we will start up again at 12:15 for a panel on legal careers and national security. For our in-person attendees, again, we've got two optional lunch sessions, so you can remain here and eat your lunch, or you can go upstairs to room 219 for an hour of professional responsibility. I am happy to report we have 2 food trucks outside to the right, Chad's One Stop and Flames and Cones. For everyone else, we will resume back at 13:30.
U.S. Cybercom has responded to Russia's invasion of Ukraine, state and federal challenges to the security of our elections, regular, consistent state and non-state actors, continued cyber challenges from China, North Korea, Iran, and other potential adversaries, and has supported responses to numerous domestic incidents. What was once left to only the kinetic is now supported or even sometimes replaced by the keyboard. Cyberspace operations are now a critical component and incorporated into military operations across all operations and geographic combatant commands. The need for legal advice and subject matter expertise has never been more relevant, both domestically and in our international operations and engagements. A critical partner supporting U.S. Cyber Command are the 54 states and territories of the National Guard, who work directly with the OSJA section responsible for cyber legal support in their domestic state capacity, as well as their liaison and partner relationships with U.S. Cybercom's plans, partnership, and policy activities. The Air National Guard also leverages its relationships with CISA and cybersecurity and infrastructure security agencies through the use of the Cyber 9 line. These partnerships help the United States protect, promote, leverage, defend, and harden our cyber needs and requirements. The ability to quickly share information to leverage the authorities secures the nation and keeps our adversaries off guard, engaging them as far forward in cyberspace as possible. As the United States continues to adopt asymmetric and innovative ways to restore our comparative military advantage and employ capabilities in joint or across domains, the total force integration of the citizen soldier remains instrumental, and we must continue leveraging our total force cyber warriors. I am proud, along with the Joint Reserve component members of our team, to continue to support this incredible and pivotal mission.